By Justice Given Reddy.
So many words. Just take paras 782, 784. There's so many words that a caste is a backward class once it satisfies these tests.
Correct. Just see, John, since that has been read, let's clear it. But just
782 for a moment, Bharat. Just kindly see that.
Okay. 778 is exactly also on that one. 778.
I just read 3 lines. Just come to 7.
Just 1 second. We'll go to it and page.
Malat, this is Malat in your PDF. And what you will find this Malat at page 693.
My lord, may kindly peruse page 779.
I just read two paragraphs. That's all. Kindly come to Malat's PDF 693. Placitum F. Placitum F, Malat. May I place it, Malat? Placitum F. Any authority entrusted with the task of identifying backward classes may well start with the castes. It can take caste A, apply the criteria of backwardness evolved by it, so to that caste and determine whether it qualifies as a backward class or not. If it does qualify, what emerges is a backward class for the purpose of 16.4. The concept of caste in this behalf is not confined to caste among Hindus. It extends so and so, so and so. Now let's come to para 784 on the next page. Again said even more clearly. Kindly come to 784. The next page.
Yes, sir.
The only basis for saying that caste should be excluded from consideration altogether while identifying backward class of citizens for the purpose of 16.4 is clause 2 of 16. This argument, however, overlooks and ignores the true purport of clause 2. It prohibits discrimination on any or all of the grounds mentioned therein. The significance of the word any cannot be minimized. Reservation is not being made under clause 4 in favor of a caste, but a backward class. Now this is important. Once a caste satisfies the criteria of backwardness, it becomes a backward class for the purpose of 16.4. Even that, this is what is being submitted right now. This answers that. And then the pre-lunch debate, the next line, even that is not enough. It must be further be found that the backward class is not adequately represented in the service of the state. In such a situation, bar of 2 has no application whatsoever. Because not only
becomes a backward class if it's so.
So, to answer what fell from her ladyship, this is the clear answer. The caste, once it satisfies the requirements given here, social educational backwardness is a backward class. That is why any.
It's clear actually, very clear.
Absolutely clear, Malaj. Absolutely clear.
Just one more paragraph, Malaj will permit. 778. That also puts it very tightly. 778. Indeed, there are very good reasons why the Constitution could not have used the expression caste or caste in Article 16.4 and why the word class was the natural choice in the context. The Constitution was meant for the entire country and for all time to come. Non-Hindu religions like Islam, Christianity and Sikh did not recognize caste as such, though, as pointed out here and above, caste did exist even among these religions to a varying degree. Further, the Constitution is supposed to be a permanent document expected to last several centuries. It must surely have envisaged that in future many classes may spring up, answering the test of backwardness requiring the protection of Article 16.4. It therefore follows from the use of the word
2 and 784 are...
779 is also important. 779.
Then one more thing, very interestingly, I just wanted to show you, I mean, we don't read it right now. You know, in earlier part in the morning session, I gave that example of the aerospace.
That's the
aerospace, that is footnote 143. At page 690, Air India versus Nagresh.
Yes, well, that's right.
What Articles 15.1 and 16.2 prohibit is that discrimination should not be made only and only on the ground of sex.
That's what 784 says, Manoj. Here it is not just that, it is also inadequacy of representation. So the only 16.2 argument is specifically rejected on this ground, what fell from your lordship, Manoj, in the pre-lunch session. Clearly.
Just all these paragraphs 766, note that 766, 771, 772 to 778, then 779, and then that's 779. That's it.
And 784.
Yeah, 82, 84, and 96, 97. 796, 97.
Complete.
I have it in a note which I'll upload, which has all the quotations, so that it's easy for your lordship.
Just one comment. All these passages are only in the context of reservation for OBCs. Now, OBCs had to be justified at that stage. Because Mandal was concerned not with scheduled castes, but with OBCs.
But Mr. Hegde, even within the OBCs, the point is that a single caste can
Yes.
become a class
In
provided. We see your point. You're saying, but no. In the case of SCs, because of Article 341,
Yes,
it's
it's
the
a separate
entirety
thing altogether. I'll put it in.
All right.
I just
We
didn't
will-
want the moment to.
Now we'll wrap up.
Carry on.
We got the point. We got the point. Let's Dr. Chauhan conclude.
Yes, ma'am. My lord,
Yes, Dr. Chauhan.
the next, my lord, issue is the theory of classification, my lord.
Yes,
How
sir.
you can classify, my lord. What Mandal has said about classification, my lord. Now, every often then, even in these proceedings,
So, what is the submission, Dr. Chauhan, on
my
classification?
submission is, my lord, they are enabling provision only for the purpose of making classification. But it is not discretionary, because it is not discretionary for the state that they can allow some people the benefit and they can disallow some people that benefit, my lord. If a person is forming part of in a list, my lord, then they cannot discriminate, my lord. And this issue was considered by the 11 judges bench in Madhav Rao Scindia's case, my lord, and even Keswanand Bharti, my lord, 486 para, my lord. The Supreme Court has said that this is a controlled constitution, my lord.
Dr. Chauhan, you've made a point. We are going to put it to the other side. And simply put, your point is this, because this is a very valid point. That suppose the state, now in this case it's two castes. Some state says that, well, out of my 86, I'm identifying only 7.
Yes, my lord.
You leave out others
Yes, my lord.
who are similarly circumstanced. Can the state do that? Can they say that, look, I have, say, 25 castes which fulfill all the parameters of backwardness.
Yes, my lord.
Out of the 25, I'll only take 3.
Yes, my lord.
Normally, conceptually, an under-inclusive classification is a valid classification.
Yes, my lord.
The legislature does not have to deal with everybody to deal with someone. But I'm not sure that can apply over here. Because if there are a range of castes which are equally backward,
Yes, madam.
can you then say I'll pick out only 2? But that again, that point is perhaps something we should leave when the challenge comes up before the High Court, you see, or before the two-judge bench, whatever
With respect, my lord.
I'll give you another example.
Yes,
Suppose in this case, they had picked out only Balmikis
yes, my lord.
and left out Mazhabi Sikhs.
Yes, my lord.
All right. Could the Mazhabi Sikhs not have argued that we are as backward as the Balmikis? Why have you left us? You are only taking the Balmikis. Or suppose they took up only the Mazhabi Sikhs.
Yes, my lord.
Can the Balmikis not have argued that, look, why are you taking up only the Mazhabi Sikhs? We are similarly situated.
Yes, ma'am.
Which means, therefore, that those who are excluded can always challenge that classification under Article 14 on the ground
Yes, ma'am.
that, look, we are equally and we fulfill all the indicia of backwardness. But the state can also rebut it by saying that we can classify castes by looking at the extent of backwardness.
Yes.
We want to deal, as Brother Gawai said, we want to confer benefits on the most backward.
Yes, madam.
But while conferring benefits on the most backward, you can't ensure that some who are most backward, are only given while the others are left out. Otherwise, this will become a very dangerous trend in, popular appeasement.
Yes, yes.
Some state governments will pick out, a few castes. Another state government will pick out another set of castes. The idea is not to allow, popular politics to play out in granting reservations.
That's why Dr. Ambedkar has said that there should be no political
So
factors, madam.
even if we don't accept your wider submission, there is undoubtedly some substance in what you people are all pointing out to us, and we'll have to tailor it by laying down criteria.
Yes, madam. But, my lord, may kindly peruse Madhav Rao Scindia judgment, my lord. 2 paragraph of, that is 11 judges bench, my lord.
We have dealt with it in Article 370 recently, the article, that is the privy purses, no?
Yes, my lord. Para 117 and 170, my lord.
What is the... point that
My
you
lord,
decide?
they say that this is a power conferred on the president to identify, but suppose the president doesn't identify, then it will be unconstitutional. He cannot do it. He has a power which is vested, which has to be exercised.
Or power to do what?
To do.
Power coupled with duty principle, my lord. That
Madhura
what?
Sindhya, yeah.
Father of Sindhya concerned with the privy person.
My lord, kindly tell that.
No, but it dealt with privy persons. It has nothing to do with Article 341.
My lord, that is there, from there we have taken that paragraph. 117 and 170, my lord. Two paragraphs are there. One is by Justice Shah and another is by Justice Hegde, my lord. Just a minute.
In Madhura Sindhya, what happened was
Yes, my lord.
that the rulers were de-recognized
Yes.
by an executive act.
Yes,
Though the constitution specifically recognized their status as rulers.
yes, my lord.
Therefore, it was struck down on the ground that what the constitution had done by an express recognition, you could not undo by an executive order.
Yes, my lord.
Subsequently, they amended the constitution to abolish privy purses. That's why in the second round, before Justice L.M. Sharma,
Yes, my lord.
the abrogation of privy purses was upheld because it was a constitutional amendment.
But that is only for the purpose of principle, my lord. That is for a different aspect. But the principle which was dealt by this honorable.
बताइए कौन सा paragraph?
My lord, this is in my sequence of submissions which we have given, my lord. There are many analogous provisions in the constitution which confer upon the president a power coupled with duty. It may refer to, we may refer to two such provisions. The president has under Article 341, 342 to specify scheduled caste and scheduled tribe, and he has done so. Specification so made carries for the members of the scheduled caste and scheduled tribe certain special benefits.
Seats in the House of
Reservation seat in the House of People and in the State Legislative Assembly by Article 330 and 332, and of the numerous provisions made in Schedule 5 and Schedule 6, it may be noticed that scheduled caste and scheduled tribe are specially defined for the purposes of Article of the Constitution by Article 366 class 24 and 366 class 25. If
what they are saying is
yes, my lord.
that since the power to, once the president makes a notification,
Yes, my lord.
thereafter any deletion has to be by a law made by parliament. The president can't just issue a notification and delete any entry.
Yes, yes, yes.
That's the point.
Well, now, my lord, because the principle which was settled in Indira Sani, my lord, in 9 judges bench, that this is a classification, my lord. Now, in Nagaraj, this honorable court has taken a view, this is a enabling provision and a discretionary remedy, which has led to scrapping of reservation in promotion almost all states, my lord.